So what we mean by corporate restructuring, so sometimes the company, due to certain circumstances, it can actually basically change the form as to how it actually operates. So several factors can actually make a company to do what we call restructuring. So it's just the change of form of operations, or basically how the company carries out its business activities. So that's what we mean by corporate restructuring. It's simply where the company changes how it carries out its operations or carries out its business activities. So also what will happen, the company can do it by looking for internal means or actually going for external means. By internal means, we simply mean that, for example, the company could decide they're going to merge some of the departments so that they can actually maybe improve on their efficiency or maybe save on costs, or sometimes they could actually basically even split the departments. So they have several departments in the company. For example, in this case, if the company has, for example, a sales and marketing department, so you can actually be able to split it and actually have a sales department on its own and a marketing department on its own. For example, in this case, the company could be having, for example, a maybe bookkeeping department and, for example, an auditing department. So they decide to basically merge the auditing department and the bookkeeping department. Maybe they are doing this to basically to be able to do what we call utilize maybe the workforce or the talent they have in the company efficiently, because they have discovered these persons who are actually basically carrying out auditing work for the company, they can be able to do proper bookkeeping for the clients of the company. Or they could decide they're going to merge auditing and actually business advisory, because those who are carrying out auditing can actually efficiently be able to carry out or do the duties of business advisory. In that way, the company is actually able to utilize the talent or the workforce they have in the company very properly. So that is what we mean by restructuring. Those are basically examples of how the company can be able to restructure. When you talk about going for external means, the company can decide basically to merge with other companies to remain competitive in the industry it is actually operating in. What we mean by this, for example, in this case, we can give best examples in maybe 2 or more industries. If you look at, for example, the supermarket industry, so that particular industry, so there's this particular supermarket, you know, now that has actually taken over the market. It is known as Quick Mart. So there was actually basically a particular point whereby, I don't know, they merged or basically they acquired another supermarket known as Tumaini. So basically they could do that to remain competitive with the other giants in the industry, like let's say, for example, by that time, Tuskys, so that they can actually take a bigger share of the market. If you look at the banking industry, we have, for example, this one, you know about it, NIC Bank actually being able to merge with Commercial Bank of Africa. So basically that one simply means that these particular 2 banks are actually merging, for example, to have huge assets or maybe to control a huge clientele base and remain competitive in that industry with other bigger players, like let's say, for example, Equity Bank. So what should actually go at home is basically what we mean by corporate restructuring. The company is basically changing the way it carries out its business activities or it carries out its operations due to several circumstances, as we've mentioned, maybe to utilize the talent it has in the company properly, to cut on costs, or to remain competitive in a particular industry, or maybe to utilize the technology acquired efficiently. So you see, sometimes, for example, banks are actually able to do away with tellers because there is new technology that is actually supposed to be utilized in terms of, for example, taking deposits and actually being able to even do what we call withdrawal of money. So that is what we mean by restructuring in a nutshell. So there are several ways of how it can happen. There are several ways of how it can happen. We can have compromises. Yes? There's someone who has a question?
Yes, kindly pardon for me the reasons for corporate restructuring.
Reasons for corporate restructuring?
Yes.
Okay. So that is basically the importance. So as I've said, corporate restructuring is where the company changes the way it carries out its business activities or operations, either by going for external means or internal means. It is simply the way the company changes how it carries out its business activities through external means or internal means. Examples of internal means: merging departments, That is an internal means. External means we could talk about merging with other companies. The importance, we can talk about to cut on costs or save on costs, ensure they are saving or basically cutting on costs. Number two, you can talk about utilize the talent they have properly, so utilize the talent they have efficiently. So utilize the talent they have efficiently. Utilize the talents they have efficiently. To remain competitive in the industry the company operates in, to remain competitive in the industry the company operates in, to remain competitive in the industry the company is operating in, to remain competitive in the industry the company is operating in. To remain competitive in the industry the company is operating in. The next one you can talk about to do away with products. To do away with products. To do away with products. To do away with products or accounts which are not performing. To do away with products or accounts which are not performing. To do away with products or accounts which are not performing. To incorporate, another one is to incorporate new technology in the company, 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 to incorporate new technology in the company. The next one is to decrease or consolidate debts. Madeni, debts, what we mean by to consolidate or decrease debts, to consolidate or decrease debts, or decrease debts, to consolidate or decrease debts, to consolidate or decrease debts, to consolidate or decrease debt. So those are some of the reasons or the importance of corporate restructuring. So they could ask what are the importance or what are the reasons as to why a company can actually restructure. So those are the importance or some of the reasons as to why the company can actually be able to restructure or change the form of how it actually operates. So I was just trying to explain some of the types of ways of how the restructuring can actually happen. So before maybe you jot down something or write down something, maybe I can just explain to you, for example, these ones that I've just listed on the board. So we have, for example, what we call compromises and schemes of arrangements. We have, for example, mergers. We have, for example, acquisitions and takeovers. We have divestitures, share capital reduction, or, for example, joint ventures. So what we mean by compromises and schemes of arrangements, it is simply where the companies, for example, the companies, debenture holders or maybe creditors decide to change their interest in the company. So they simply enter into compromises with the company. For example, if the company is not actually able to meet the obligations, because as we said under debt capital, that the debenture holders of the company actually expect what we call interest from the company and the principal amount. So in this case, if the company is not actually able to pay those particular obligations in terms of the principal and interest, it simply means that these debenture holders could actually recommend the company be liquidated. So instead of having to go that particular route, these debenture holders can basically change or convert their interest in the company. Instead of them actually having to be debenture holders, they simply convert their interest in the company. They simply convert their interest in the company and they become shareholders. This one will simply lessen the burden, of the company, because in this case, if you are a shareholder, you will simply expect dividends from the company. And as I told you previously in my previous classes, dividends will actually only be paid out of what we call distributable profits. So if the company is struggling, it simply means that it is not actually making profits, and therefore that dividends won't actually be paid. But for the interest, for the debenture holders or the creditors, it is mandatory to be paid as to whether the company has made profits or not. So if that one actually happens where the company is actually struggling to be able to pay these particular amounts to creditors or debenture holders, they can simply convince the debenture holders to convert their interest in the company. And of course, instead of them being debenture holders, they actually become shareholders. If they do that, they simply say the company has been able to enter into what we call compromises with the debenture holders, and they have crafted a scheme of arrangement whereby they are going basically to become shareholders of the company. With that, basically, the company will actually be able to restructure, and it can actually be able to avoid actually being maybe liquidated by the debenture holders. So it is simply where the company enters into compromises and basically crafts a scheme of arrangement with, for example, the creditors of the company, and they convert their interest in the company and they become actually shareholders. That one actually simply lessens the burden of the company, because these shareholders, the expectation is only dividends, which is actually only supposed to be paid out of profits. If there are no profits, they simply come out empty-handed. For example, in this case, for the debenture holders, the interest is mandatory as to whether the company has made profits or not. So sometimes we normally say these particular ways of restructuring are actually what we call alternatives to actually having to be liquidated or actually being wound up. So sometimes they could ask, what are the alternatives to actually being liquidated? You can simply be able to mention this one, because with this one, the company can actually escape ending its life or actually being liquidated, or basically the creditors or debenture holders recommending it be liquidated, because they have now sat down with these particular parties and they have agreed to come up with a scheme of arrangement. So mergers is simply whereby two or more companies combine their assets. So once this one has actually been taken or basically proposed by the board of directors, it will basically be presented, for example, to the shareholders of the company. So once they approve, the two companies can actually be able to merge their assets. We've given dominant examples, NIC Bank and Commercial Bank of Africa. So they basically merged to form what we call NCBA. So it became one entity. So they simply combined their assets. So there are several things that are actually supposed to happen here. For example, there's what we call post-merger integration, because they have to deal with things like, let's say, for example, culture shocks, which we are going to look at. Culture shocks in terms of the employees. So we need to prepare them, for example, in advance, that we are going to be able to merge and become one entity with another entity. You know, the culture at NIC, you know, the same as with the culture at Commercial Bank of Africa. Maybe the employees here are used to basically working up to 3 p.m. The employees here are used to working up to maybe 6 p.m. So having to combine the two cultures, it simply means that there has to be proper communication to the key stakeholders, for example, the employees, so that this merger might not actually fail. Because if you don't basically prepare the employees very well, it is likely to fail, because they are supposed to play a key role when the merger is actually supposed to happen. So that is basically what we mean by a merger. So simply two entities or two companies combining their assets to become one entity, What could actually happen, one of the entities can actually be absorbed by the other, such that it loses its identity. That's what we call it absorption. Or sometimes they could actually basically decide to merge and actually basically maintain their identity. So if that one actually happens, you can simply say, for example, one of the entities has actually been absorbed by the other. Acquisitions, what we mean by acquisitions, it is, for example, that circumstances or situation whereby you find we have this one meeting. So you know one of them will actually simply disappear. So for mergers, we have this one. So they basically come together to form a union, so under a merger. But under this one, where a cat meets a rat, this rat will actually simply disappear. So that's what we mean by acquisition. So one of the entities actually acquires the other entity, and it is actually able to control its activities or actually affairs. So in this case, for example, we could talk about Kenya, for example, Kenya Commercial Bank having acquired, for example, Jamii Bora Bank. So they simply changed the name. I don't know if it's to Kingdom Bank or something. So they acquired Jamii Bora Bank. So if this one actually meets this one, the rat will actually disappear. So one of the entities actually disappears. And of course, all the activities are actually controlled by the cat. So we normally have what we call the target company. And of course, we have the target company and the predator. So the predator is like now the cat. And of course, the target company is now like the rat. So the predator is the cat. The target company is like the rat. So the rat will actually simply disappear. So once this one actually meets the husband and the wife, they form one entity. Is like now the merger. So it's like a 50-50 coming together. So divestitures, what do you mean by a divestiture? A divestiture is simply whereby the company decides to do away with non-performing product lines. So they do away with that particular product and all assets accompanying that particular product in terms of, for example, the production and maybe technology. So they sell it to another company. For example, the company could be having several product lines, but one of the product lines is not actually performing so well. So what they decide to do is to sell off that particular product because it is loss-making to them. And of course, it is just being sustained by these other product lines. So we could talk about, for example, if we have these particular companies, so we have this company. This company is actually famous for producing alcohol. But of course, they could have one product that is actually a soft drink product. But this product is not actually performing so well. So they could decide to sell off that particular product to another big company known as Coca-Cola. You know what Coca-Cola does? It basically specializes in soft drinks. So they sell off this particular product because it is just being maintained by the alcoholic products, which are actually very profitable. So if the company discovers that, they can simply be able to restructure by simply selling off this particular product line to this other company, because maybe they have the expertise or knowledge of how to tap into the market of soft drinks. So they can sell off this product. If they do that, we say the company has been able to divest. So they simply do away with product lines or non-performing product lines of the company, and they sell them off to other companies so that maybe they just concentrate on the most profitable products of the company, or the ones they're actually able to sell very easily to maybe the customers. Share capital reductions, I think this one we've already looked at it. We looked at it under share capital. Share capital reduction is simply where the company decides to reduce its capital in the company. So due to maybe several reasons, maybe it has excess capital. There are no assets to represent the share capital, so they can decide to reduce the share capital. And then we have joint ventures. So joint ventures is simply whereby, or a joint venture is simply whereby two entities contribute capital. So they contribute capital and actually invest in one entity. So maybe this one produces 50% of the capital, the other than 50%, and they simply put in one entity, or basically invest in one entity. So that is what we call a joint venture. So in a nutshell, or basically in short, that is what we mean by corporate restructuring. That is what we mean by corporate restructuring. And basically that is the importance and of course some of the types of corporate restructuring. So our key focus here will basically to look at what are compromises, what are mergers and how it happens, and what are actually acquisitions and takeovers. For these other ones, you can just actually be able to understand them. So you have others like, let's say, for example, reverse merger. You can have what we call reverse merger. So reverse merger, don't confuse it as the opposite of a merger. What we mean by reverse merger, a reverse merger is whereby shareholders in a private company, so they have their own company, which is actually a private company, decide to go public, or basically decide to convert their interest into a public company by acquiring an already existing shell public company. So there's a public company that has been registered, but it's not actually functional. It is just idle. It is just there. So what they do, because they want to convert their interest from actually being a private company, they simply acquire or buy that particular public company. If they do that, we say they have done what we call a reverse merger. It is normally advantageous because the company will actually avoid what we call an initial public offer. They don't have to come up with a prospectus as a private company to be able to convert it into actually basically becoming a public company. So they simply just, for example, leave the private company and invest all their interests in the shell public company that has already been registered. So it avoids the hassle, the time, the costs involved in doing an initial public offer, having to basically invite people to buy the share so that it can become a public company. If they do such, we say they have done what we call a reverse merger, converting their interests from a private company and actually becoming a public company by simply buying or acquiring an existing shell public company, public company. So maybe we can start by looking at what are compromises and schemes of arrangements. So you can just be able to see. So I kindly repeat the divestiture. So let's just see. There's a bit. So divestiture means an outsell of all or substantially all the assets of the company or any of its business undertakings or divisions, usually for cash or for combination of cash and debt, and not against equity shares. In short, divestiture means sale of assets, but not in piecemeal manner. Divestiture is normally used to mobilize resources for core business or business of the company by realizing value of non-core business assets. So what they talk about by non-core business assets is what I'm just talking about, non-performing products, which are not performing. You just sell them off, or maybe you will have several divisions of the company. So this one deals with maybe manufacture of maybe stationery. This one deals with maybe manufacture of books. So the one for manufacture of books is actually performing so well than that one of stationaries. You can sell that division of stationery and basically take those assets in terms of money and invest in this one that is actually performing so well. For example, if you are dealing with maybe clothing, so you have a line that is dealing with maybe footwear, the other one is dealing with maybe ladies cloth, the other one is actually dealing with maybe men's suits. So the one for ladies is actually doing so well. So ladies are actually really acquiring cloth or maybe their shoes. But the one for suits for men is not actually performing so well because men are not actually basically doing a lot of shopping each and every time. So once they have maybe 6 suits or 7 suits, they're actually good to go. But for ladies, they might probably maybe do a lot of shopping each and every month once they get their salary. But for men, so just once in a while. So you find that this one for men is not really performing so well. So you decide, let me sell it off and basically just concentrate on ladies' shoes and of course, ladies' clothing. So you do away with that division or sell off that particular product line to another person who maybe knows how to go about it and actually put the resources or basically put the resources in the performing areas of the business. So we have another one which I had not mentioned, demerger. So demerger is now like the opposite of merger. So demerger is a form of corporate restructuring in which an entity's business operations are segregated into one or more components. Demerger can take 3 forms. You can have spin-off, split up, or maybe split off. Then reduction in capital, what I've just gone through. So joint venture is an arrangement in which 2 or more companies called joint venture partners contribute to the equity capital of a new company called a joint venture in pre-decided portions. So maybe they agree this other one is going to contribute 60%, this one 40%, and they contribute the capital and invest in one entity. So buyback of securities is actually also one of the ways of actually restructuring. So when the company is holding excess cash in terms of capital, they can simply be able to buy back the securities or basically buy back the shares of the company. So we have these other ones that I've just mentioned briefly, mergers or amalgamation. A merger is a combination of two or more businesses into one. Amalgamation is the merger of one or more companies with another, or the merger of two or more companies to form a new company in such a way that all the assets and liabilities of the amalgamating companies become assets and liabilities of the amalgamated company. So it's simply whereby two or more companies combine their assets and all their liabilities to become one entity. It can be through what we call absorption. So what do we mean by absorption? So absorption is a combination of two or more companies into an existing company. All companies except one lose their identity in such a merger. So you can see what they are saying. What we mean by absorption is like one of the companies absorbs the others. It absorbs the others. So the other one loses the identity. Like in this case, we could talk about, for example, QuickMart simply absorbing Tumaini. Tumaini loses the identity. And of course, the people just know, like, or assume that particular supermarket was actually QuickMart, yet it was actually absorbed. So they merged with another one and it was actually absorbed and lost its identity. So people no longer know about what we call Tumaini. They just know QuickMart. But of course, they merged and actually formed one entity. So that's what we mean by absorption. They're simply merging by absorption. One of the companies actually loses its identity. So maybe you can give another example in the banking industry. For example, we used to have a bank known as Gyro Bank or Giro Bank. I don't know if some of you know it. So like this, Giro Bank. So Giro Bank, I don't know if it was acquired or they merged with I&M Bank. So Gyro Bank actually lost its identity. So you can Google online what actually happened with Gyro Bank and I&M. So I&M Bank basically acquired, I don't know, they acquired or they merged with Gyro Bank. So all the banks that were actually basically known as Gyro Bank were basically rebranded and actually became I&M Bank. So it was actually simply absorbed and lost its identity by I&M Bank, by I&M Bank. So merger through consolidation is a combination of two or more companies into a new company. In this form of merger, all the companies are legally dissolved and a new entity is created. So now in this case, both of them lose their identity. So they lose their identity and actually they basically form a company under a new name. So we can look at basically look at more about what is corporate compromises and schemes of arrangement. So what do you mean by this? The provisions of the Companies Act regarding compromise or schemes of arrangement are mainly applicable to those companies liable to be wound up under the Companies Act. So the provisions can apply to companies which are in the process of actually winding up. So it applies to companies, especially those ones who are basically looking at alternatives to actually basically avoiding what we are calling winding up. So the provisions can apply to companies which are actually in the process of actually winding up. By making these provisions, the law provides for a kind of substitute for winding up, which will thereby save the company from going into liquidation. So as I've told you, a compromise and a scheme of arrangement is one of the escape routes for a company actually avoiding ending its life. When they talk about liquidation, as I've been clearly telling you all the time, it is the process of ending the life of the company. So to avoid this, they could actually basically come up with this particular restructuring option known as compromises and schemes of arrangement. So what is it? What do we mean by this? A compromise includes any settlement of a matter or dispute of the company by the consolidation of shares of different classes or by division of shares into shares of different classes or both. It also includes variation of special preferential rights on preference shares. So you come up with maybe arrangements that are simply comfortable with the key stakeholders of the company. So the teacher was actually basically giving an example of, for example, the creditors. So it can actually also be utilized, for example, in the case of, let's say, for example, preference shareholders. So as you know, for preference shareholders, they get dividends at what we call preferred rates. So in this case, they could actually be getting dividends, let's say, for example, at 10% preference shares. So simply they enjoy dividends at the rate of 10%. So they can simply come into an arrangement and of course agree that it won't actually be 10%, it will basically be maybe 3% or maybe 2%. So they have actually been able to compromise, to come up with compromises with the company instead of having to pay the dividends at the rate of 10%, because maybe they are seeing the company is actually struggling. So they agree it will actually be at 3%. So that's what we mean by compromises. So a scheme binds all the parties, including the decisions or those ones who have not actually agreed to it, so long as the majority have actually been able to approve of it. So whenever a company makes a scheme or a compromise or arrangement, then old contracts are modified and new contracts come into force to replace the old ones on terms that are aimed at stabilizing the company's financial structure. So a scheme of arrangement may involve the following changes. For example, as we've said, debenture holders or creditors may be agreeing to accept a reduction in the rate of interest or to surrender the rights to accumulate outstanding interest or accept shares. So they could accept to get shares in the company as debenture holders to basically simply lessen the burden of the company. Another option, it could be preference shares may be converted after consultation with preferential shareholders into equity shares, or their rate of dividend may actually be lowered. So just what I'm saying here, from 10% to 3%. And of course, I've told you the effects. It will lessen the burden of the company in terms of actually having been able to pay exorbitant or basically high dividends. So because the company is struggling, so that is actually one of the ways it can lessen its burdens so that it can actually maybe remain stable and actually avoid actually being liquidated. So those are the options that can actually basically be deployed by the company to basically be able to restructure and what we are calling compromises and schemes of arrangement. So what is normally the procedure? So there's a procedure followed before the company can actually be able to come up with this particular mode of restructuring known as a scheme of arrangement and compromises. So where a compromise or an arrangement is proposed between a company and its creditors or its members, this is the procedure that must actually be followed. Number one, the courts may, on application by the creditors or members or liquidator, order a meeting of creditors or members as the case may be. Such a meeting may be called and conducted in a manner the court will actually direct. So before this one actually happens, the key stakeholders have to come together in the company. For example, the members, the creditors, the liquidator himself, who was actually basically going to liquidate the company. And of course, they agree as to how they'll be able to craft or come up with that particular scheme of arrangement. So they're supposed to discuss by themselves. So they agree that you as debenture holders, so that you can avoid this liquidation, why don't you convert your interest? So they write it down in a resolution at their meeting. So this is the one that will basically be used to apply to the court. That these are actually basically the proposals we've come up with on what we are calling our compromises and schemes of arrangement, so that the court can actually be able to assess and actually be able to know this scheme that has been crafted in the company, is it in conformity with the requirements of the Companies Act? Because it must actually basically follow the procedures as required under the Companies Act when they are coming up with a scheme of arrangement. So the reason as to why the court will actually basically have to be petitioned to approve of the scheme of arrangement is for the court to assess whether proper procedures have been followed in crafting the scheme of arrangement. That's why they're saying there'll be an application after a meeting of the key stakeholders. Who are they? It is the members, creditors, and of course, the liquidator of the company. So the scheme should actually be approved by the majority in number, representing not less than 3/4 in value of the creditors or members. So the scheme should actually be approved by the majority before they petition the court. So the scheme will be sanctioned by the court, in which case the court will have to determine whether the scheme complies with the law. So as I've said, it should actually comply with the Companies Act or requirements of the Companies Act. So that is the major role of the court there, just being able to look at that particular scheme of arrangement as to whether it is actually in conformity with the requirements of the Companies Act. Then, where the scheme of arrangement involves reduction of capital, the court must not sanction it unless a special resolution for the reduction of capital is passed in accordance with the provisions of the Companies Act. So I think this one we've already looked at the procedure of share capital reduction. We also said the court is normally involved and it has to approve the share capital reduction of the company. The court order is not effective unless a certified copy has actually been filed with the registrar. So what they mean by this, so once the court has assessed, it has seen everything is actually okay, they'll simply be able to give out what we call an order for approving a scheme of arrangement. That copy of the order from the court, it should actually be filed with the Register of Companies. So a copy should actually be taken to the Register of Companies so that the registrar can actually be aware that there is actually a change, for example, in the shareholding of the company, or the company intends to do such a change of shareholding or arrangement with maybe the creditors or maybe other shareholders in the company. A copy of every such order shall be annexed on every copy of the MOA that is actually subsequently issued by the company. After an application for the sanction has been made, the court may at any time stop commencement of any proceedings against the company or any proceedings against the companies. What they mean by this, so once the application has been received by the court can stop any person having to sue or the company having to sue any other party or bring any proceedings against the company in a court of law. So huwezi accuse kampuni ama peleka hiyo kampuni kwa koti kama koti ja approve, because it is actually in the liquidation process and therefore the court is actually very involved. So before you sue such kind of a company, you must actually seek the permission of the court, because there are other plans that are being made in the company that must actually be concluded by the court. So you can't basically bring any proceedings in any court of law unless the court has actually been able to approve of it, so that you can actually be able to bring the proceedings. So any order of the court is open to an appeal at a higher court. So any person can actually be able to appeal that approval by the court. For example, if they are given an order approving a scheme of arrangement, so if you have those ones who are actually basically not for it, they can appeal at a superior court, for example, the Court of Appeal, so that it can be looked at into and determined as to whether that particular scheme of arrangement is valid or not. So what will happen after the court has given out the order, the court will actually also be involved in the supervision of the implementation of the scheme of arrangement. Remember, they have just come up with a scheme. Now they want to implement it. So they were just in a meeting. So they were basically crafted it. In this case, debenture holders, you will no longer be debenture holders, you will become shareholders. Your interest will be converted into a number of worth of shares in the company. So that has to be implemented in the company. So the court does not actually just leave at that particular point, they are giving the order. They'll simply actually be able to come in and actually be able to supervise the implementation of the scheme of arrangement, because it's actually a process. So sometimes you can actually agree something with someone, then he does what we call anakuruka. He does what we call anakuruka. I think you basically come across this. You agree something with someone, then eventually anakuruka. So to avoid kurukana, the court will be there to supervise the scheme of arrangement. To avoid kurukana between the company and these other key stakeholders like the debenture holders, the court must supervise the implementation of the scheme of arrangement. So the powers of the court, what will the court do? As the teacher is saying, to supervise the carrying out of the scheme of arrangement or compromise. Number two, power to give direction or to make such modification as may be appropriate for the proper working of the scheme of arrangement. You know, the situation here is actually very delicate. The company is avoiding liquidation. So the court will give guidance as to how this particular scheme of arrangement can actually be very successful to avoid what we call liquidation. So that's why the court will actually be there to supervise. Number three, well, it is satisfied that the sanction or compromise or arrangement cannot be worked satisfactorily, it may on its motion make the order for what? Compulsory winding up. So now the court has tried to basically ensure that this particular scheme of arrangement is working. But the court has discovered hiyo kurukana bado inaendelea in that particular process of implementation. In this case, the company had agreed with the debenture holders that, of course, they can be able to get this worth number of shares in the company, but it's not happening. This scheme of arrangement is not actually working. what the court will simply be able to do, it will recommend the life of the company comes to an end. Remember, this was actually an escape route from the company being liquidated, but it is not working. What will happen? The court will simply basically recommend or give out an order for compulsory liquidation of the company. The company now life will come to an end if this scheme of arrangement is not actually working. So that's what we mean by a scheme of arrangement, and that is actually basically how it can happen in a company, how it can happen in a company, So they could ask, what is the role of the court in a scheme of arrangement? What is the procedure of a scheme of arrangement? So they could ask such kind of questions, or they could ask, what are the provisions under the Companies Act with regards to a scheme of arrangement? So that is basically what has been outlined, the statutory provisions. You can talk about these particular procedures. You can talk about these particular procedures and what the court does in a scheme of arrangement or a compromise or an arrangement, as we've seen. That's what we mean by a scheme of arrangement, and that is how basically a company can restructure through what we call a scheme of arrangement. So I want us to look at mergers. So as I've told you, a merger is simply whereby the assets of two or more companies become vested into one entity. So what is the procedure? What will actually be involved in what we call a merger? So what will happen? Number one, there must be an identification of the industry which meets the strategic conditions set by the company for the merger. So the company won't just wake up and they say, you are going to basically merge with this other company. So maybe they could even involve experts to be able to do an analysis. In this banking industry, which is the best bank we can actually be able to merge with? What are the reasons? So they have to basically do an analysis, assess the industry, which is the best for choosing a company to merge with. There'll be what we call selection of a more desirable sector from the industry. Then, of course, choosing the potential companies considering aspects of such as size and the competitive strength of the company. So there's usually a very proper analysis of maybe the industry, identifying the key company to merge with, how competitive is it in that particular industry, what are the advantages that are likely to arise if basically we merge with this particular other company. So they look at all those analyses before they can actually be able to identify the best entity or company to be able to merge with. Consideration of the financial obligations associated with the merger. So the companies are compared on basis of their return on investments and future expected returns. So, during merger, there are costs involved. For example, maybe during this particular merger, maybe you might decide to do away with some of the staffs. So you must give them what we call send-off packages. So you might discover, like, let's say, for example, after the merger, once the company has restructured, they do away with, let's say, for example, 400 employees. Their send-off package is coming to, let's say, for example, 10 billion. Do you have 10 billion as a company to pay for such immediately? You have to do those kind of analysis. So what are basically the financial obligations that are actually basically being involved in the merger? Maybe you have to do away with the number of directors. So basically they have to be compensated for loss of office. Do you have that kind of money to compensate them? So you do those particular analysis and see whether it makes financial sense to be able to merge with another company. So suitable companies will be shortlisted basing on maybe their market share and sales volumes, or maybe they look at several factors, return on investments. So then they'll basically review the best timing for the merger. So what is the best time that the merger can actually be able to happen? Then they'll basically go to the negotiation stage, whereby the two companies or the two board of directors for the two companies have to negotiate, for example, in terms of the share exchange ratio. For example, if you have two shares in this company, once they merge, how many shares will you be having when it becomes one entity? What is the share exchange ratio? So then after that, it has to be approved by the board of directors. Then, of course, also the shareholders of the company. So the key players or the key stakeholders, shareholders, or members of the company, they must approve of the merger. They must approve of the merger. So it will basically be presented at a general meeting of the members of the company. Then, of course, they have to basically make the assessment and maybe be advised as to whether that particular merger is actually best for them or not. Once they approve, other key stakeholders like financial institutions, like, for example, lenders to the company, creditors, will actually also be involved. Then approve of the High Court, which issues a winding up order of the amalgamating company. So remember, once they merge, the previous companies will be wound up or liquidated. So once they merge, they form one entity. The previous companies will actually be wound up or basically be dissolved at the registrar's office. Then what happens next is what we call the integration stage, which is actually also a very key stage that should actually basically be handled very carefully. For example, I was talking about having to handle things like, let's say, for example, culture shocks in terms of maybe the employees. So the culture of the employees in the two companies is not actually similar. So you have to basically work on it so that basically these particular persons can actually be able to work as a team eventually after the merger has actually happened. There should actually be what we call effective communication at each and every stage to the key stakeholders. Let's say, for example, the shareholders, the creditors. So that's what we call post-merger integration. So it is important to plan for post-merger integration. After you merged as entities, what will happen? What are the plans you should put in place to ensure the merger is successful or to avoid what we call failure of a merger? So which refers to how the company will integrate for smooth functioning. A company can undertake the following measures to achieve a successful post-merger integration. First of all, articulate the vision and business benefits of the merger or acquisition. So remember, these two entities, they have different visions. So this other one had its own plans for the next 5 years. This other one had its own plans for the next 5 years. So the plans are not actually in sync. So these ones are taking a different direction. So now they have to basically ensure that there's actually what we call a common vision between the companies that have actually been able to merge. Develop an effective integration plan. So identify, prioritize, measure synergies long before the deal goes through, preferably at the due diligence stage. Then we have what we call synergy discovery and tracking. What do you mean by synergy discovery and tracking? You must actually clearly identify what are the advantages arising out of the merger quite early enough and take advantage of it. For example, in this case, when you talk about NIC Bank having to merge with Commercial Bank of Africa, these two banks are likely to control a huge clientele base. For example, in this case, if this one had 2 million as customers, this one had 1.5 million as customers, they're likely to control almost maybe 3 million or maybe 3.5 million customers. So they have to discover how they can take advantage of this huge clientele base. Which kind of products are they like to basically introduce to them so that they can actually maybe remain very stable in terms of profitability. So those are some of the advantages that should actually be able to track quite early enough. Another advantage it could be these two entities, they are likely to basically control huge base of assets, a lot of buildings they'll have, a lot of infrastructure they'll have. So how are they going to basically take advantage of these particular assets they have to ensure maybe efficiency in their operations? So there should be what we call synergy tracking, advantages arising out of the merger quite early enough and be able to ensure that you take advantage of such advantages. Then protecting human capital. The human resource should be handled with due diligence and also to achieve benefits of integration. So the human capital should actually be handled very carefully, because if these people you are depending on, for example, all the employees decide not to come to work for like maybe a week, do you think the merger will actually be successful? Because they are the ones who will basically be involved in most of the aspects in terms of the merger. So they should actually be handled very carefully when the merger is actually supposed to happen. Ensure effective communication at each and every stage. For example, in this case, to the customers, you tell them quite early in advance, let's say, for example, a year before, this is a resolution that has actually been approved by the board. You're going to merge with this particular other bank. the shareholders should actually also be communicated to quite early in advance when they are supposed to do the approval or basically pass a resolution approving the merger. In this case, for example, to the customers, what will be the new name of the bank? So they need to know, will their bank accounts remain the same, or basically are they going to change the bank accounts? What will happen in terms of, for example, the loans they had taken in the two banks? What are they going to do with them? Will the interest rate change? What is going to happen? They should actually what we call effective communication at each and every stage of the merger. Then the last one, addressing people dimension. So in this case, we are talking about, for example, the cost savings through workforce reduction and through pension and benefits integration, HR transformation, where required cultural integration and employer of choice consulting is actually very important. So are you going to basically cut on costs in terms of reducing the number of staffs? What are you going to do to them? Are you going to give them send-off packages? Are you going to give them their pension? Do you have such kind of money to pay for such? So addressing the people dimension in terms of, let's say, for example, the culture shocks. Are you able to basically handle such, or maybe train the employees to be able to cope up very fast so that to ensure efficiency and operations are not actually basically stagnated after the merger? These points are actually very key to ensure what we call a successful merger. So, now in the exam, they will basically ask, what are the reasons that have led to failure of mergers? What are the reasons that have actually led to failure of mergers? So what should actually come to your mind very fast? Just connect with these particular points. Failing to address the people dimension and to explain, not protecting the human capital, not developing an effective integration plan, not being able to articulate the vision, or basically tracking the synergies that are likely to arise out of a merger quite early in advance. So these are basically major points to be able to observe to ensure there's what we call a post-merger integration that is actually very successful. So it is normally a process after the merger has happened, so that it can actually become a very successful merger. So these points should actually be very key or be taken or observed when the merger is actually supposed to happen. When it's actually supposed to happen. So that's what we mean by a merger, and that's what we mean by compromises and schemes of arrangement. So I think for today, I'll end there. So next time, I think I'll wind up with the reconstruction and takeovers and acquisitions, and I think we'll be through with this topic. So it ends here. Not a long topic. This is the last point. So alternatives to, or basically, what are the ways a hostile takeover can actually be avoided, or basically the acquiree can avoid a hostile takeover by the predator. So we'll be able to see the procedure of acquisitions and takeovers. We'll see it is regulated by the Capital Market Authority. Other players are normally involved, like let's say, for example, the Competition Authority, the Nairobi Securities Exchange. So they will actually basically be involved in what we call an acquisition. And of course, what are the procedures of an acquisition, and what are the plans that should be put in place by the target company that is supposed to be acquired. So our major focus is normally actually compromises, mergers, and simply acquisition. These are the ones you can just be able to just understand what they are, because maybe in the exam they could ask, what is a reverse merger? What is a joint venture? They could ask, what is a divestiture? What is a share capital reduction? So you should actually be able to know them. Should actually be able to know them. So unless there's a question, you can ask a question. You can ask a question. I can see my camera has gone off. You can ask a question. Paul, do you have a question?
Not really a question, but regarding there's someone who was requesting that we have a discussion. I don't know what the members decided on WhatsApp.
On WhatsApp. I think it was it Winnie who was trying to set up that particular discussion, but I saw some members, I don't know, they are combining or what. They don't even have a free day. I don't know what is the issue. They don't even have a free day. I don't know, they are combining or they are doing 4 subjects or 6. So okay. What did you guys decide? Maybe we can hear from Martin. You can hear from Martin. Martin, what do you think?
I'm okay with Saturday.
Saturday, what time?
Around 6.
6
Because
p.m.
of because of the guys who attended the SDA guys.
Okay. What about Susie? Susie? Can see Susie here. Susie, what do you say? Okay, I might avail myself. I'm comfortable with Saturday, especially those evening hours. I'm comfortable. I can avail myself. So it's just for you to decide the time.
Okay, then I think we can proceed. We can escalate the discussion to WhatsApp so that we agree with Saturday in the evening. We have also to consider those who are going to church. Yeah, to be fair with everyone. Yeah, and also if your availability, so that we don't assume that we'll be available as from 9 to 11. Then maybe you are not available. Yeah.
For me, Saturday I cannot be available morning hours. So I can only be available from those late hours. It's a bit okay for me. So probably maybe from 2 up to around 6 there, it's okay for me. But morning hours I'm not available. From morning hours up to around 1, around 4 there, I won't be available.
Okay.
So I think you can just decide on WhatsApp. Then we can see. I can avail myself for the class, and maybe I agree. I can create the class. Then we can have the discussion. I have no problem.
Also, I can suggest that now that Winnie is the one who brought up the discussion, if she has like maybe on the topics that she will wish us to discuss, then of just coming to class and then we start asking what are we discussing. So Winnie, it will be okay if you provide the agenda of the discussion.
Yeah, it's important. Maybe you can say Winnie is not talking. Winnie, are you here? Winnie, what do you say? Okay, you can maybe just suggest on the WhatsApp group. Me, I have no problem. You can choose any topic and we come and discuss. So long as you just say this particular topic, we have a challenge. I have no problem. We'll just discuss. We'll just discuss that particular topic. But as I told you earlier, I intend we finish up with this particular syllabus before the end of this month. So I hope I'll be able to achieve it. I'm hoping I'll achieve it, so that the remaining 2 weeks in December we'll just do some form of revision here and there on major areas that are likely to be tested in the exam. Then of course you guys should actually be ready for the exam. So that is my intention, just to wind up in the next 2 weeks. Then the remaining 2 weeks of December, just pure revision of the major areas that are likely to be tested in the exam. But of course, I'll be sharing some model papers. Ensure you go through them. Just go through. When I post on the group, just go through them and read during your free time. Then when you come in the class, when I do the discussion, sometimes these 2 hours of ours is usually very limited. So you might think you'll touch on almost everything. Then you fail to maybe cover some few areas here and there. But of course, I'll touch on the major ones. I'll touch on the major areas that are likely to be tested in the exam. So that is the time you need to be very keen. Just be very keen during that time. Anytime the teacher posts anything in the group during that time, don't fail to open it. Just open it and look at it. What is it? Because sometimes you've seen students just having to regret, I wish I had actually maybe opened this one and read. So when the teacher posts something during that time, just open it and have a look at it. What is it the teacher has actually been able to post? Because when you come for the discussion, most probably those things are posted in the group. I might not have time. I might be wishing I get time to go through all of them, but I don't get the time to go through all of them because the time is limited. like these 2 hours of hours. So I think that will be okay, and you guys should actually be ready for the exam. As I told you, this particular paper is actually not very hard. It's one of the simplest papers that you'll ever come across. What you need to do is just develop the interest, and what you'll discover if you come to the class, that particular notion that company law is difficult will actually be gone away. If you attend all the classes, I don't think company law should actually be a difficult paper. It is actually very simple. And as I told you previously some time back, in this particular paper, don't be surprised. You'll go to the exam room. The students will start walking away out of the exam room after an hour or maybe after 1.5 hours. So if you are well prepared, you'll be one of them. If you're well prepared, you'll be one of them. I've had the experience, students have taught. So they just go to the exam room. After 1.5 hours, they tell you, teacher, we are actually through with that particular paper. So as I've told you, if you basically just go to the class, listen to the teacher, just listen to what this particular teacher is saying. You take your short notes very comfortably. You sit back and take your short notes very comfortably. And of course, follow each and every point that the teacher is actually teaching. Come for the revision classes. The major areas the teacher is actually basically mentioning, you go through them, just go through them. If you go to the exam room, basically this paper will actually be very easy for you. And of course, you can walk out of the exam room clearly knowing that this particular paper I'm going to pass. Because if there are 7 questions, you are given an allowance to basically choose just 5. Out of 7 questions, you've been with this particular teacher for all the all the topics and all the revision. How do you feel basically to get like almost 5 of them that you can be able to answer comfortably? So the chances are actually very high, especially if you've basically been in a class. This particular paper will actually be very easy for you. So you guys can have a good night. I think we'll meet next time. And once that particular discussion is actually basically decided upon, I'll avail myself for that particular session. And take you through or guide you through on how you're supposed to basically maybe approach some of the questions. So I would suggest maybe you go the question approach. If you choose a topic, go the question approach. The question approach, basically, you'll basically be able to discover a lot, how to answer questions. Of course, basically you'll also discover that something else related to that particular question. Because as we go through the question, I'll mention something related to the answer of that question. That if it is basically a question about, let's say, for example, the rule in Trevor versus Whitworth, what does it mean? Of course, if you go through that one, I won't fail to basically mention you need to know the exceptions. So it is important that once you decide, you can use the question approach. It will be a good discussion. So you guys can have a good night. We'll meet next time in our next session